Hello there, Andrew Bethel with the Bethel Law Corporation. We are an estate planning firm located in Southern California. And one of the most common questions we get in our office is just what documents are essential or required in order to have a complete estate plan. Now, a couple different firms might consider an estate plan complete with different factors in there, but at our firm, we believe that an estate plan is really complete when it covers all the necessary bases that would apply to just about everybody. Now, this list that we'll talk about, it's not going to be all-encompassing for every particular circumstance you might come across, but it is going to cover all of the common things that we see in just about everybody's situation, and these documents can work within one's family and work with whatever situations they might find themselves in later on. So firstly, at number 5, we have the retirement plan documents or your life insurance plan documents. Now, this one might sound a little bit like I'm bending the rules here because I'm talking more about a group of documents here. But really, your retirement plans or your life insurance policies, those are things that can provide some immediate liquidity into your estate in order to pass something down onto the next generation. In fact, life insurance policies are very, very common in the estate planning world in order to provide that immediate liquidity for family. Now, that can be to cover smaller expenses like, for instance, a funeral or maybe just whatever smaller outstanding debts you might have. It can go up to covering things like a mortgage on a property, or just be a large policy in order to have a large influx of cash into one's estate in order to have that pass on to the next generation. So it might sound a little bit weird saying that first off we need a grouping of documents here, but they can all kind of operate similarly in those retirement documents, those retirement plan documents and life insurance policies. They can provide that instant or very quick liquidity into one's estate. Next, at number 4, we have the Advanced Healthcare Directive, sometimes called a Healthcare Power of Attorney. And what that is a document that allows others to operate on your behalf in an emergency or when you're in a situation where you're incompetent, whether you be in a coma or, for instance, you start suffering from dementia and you're not able to manage all your medical decisions. That Advanced Healthcare Directive elects somebody called the agent to step in on your behalf and manage your medical care as well as manage your medical records. And on top of all that, in the Advanced Healthcare Directive, you also set the parameters for what you want for your care. So that's where you would set things like whether or not you're open to blood transfusions or whether or not you're into organ donation. You would set out those conditions in your Advanced Healthcare Directive, and your agent would have to follow those wishes, but would be the one to call the shots when it comes to when to provide care and when to step in incapacity. Now, kind of related to that is our number 3 document, and that's the Financial Power of Attorney. So just like the Advanced Healthcare Directive, the Financial Power of Attorney allows someone to step in the case of an emergency or incapacity in order to manage your finances rather than your healthcare related decisions. So the Financial Power of Attorney allows that person to step in and manage your assets, including paying bills, covering outstanding expenses, even just managing and balancing your checkbook. And there's different parameters you can place on that financial power of attorney where that person, that is the attorney in fact, can step in. You can limit when they can step in. So for instance, you can sign a financial power of attorney, but it won't be effective immediately. It'll be springing. That is, it won't come into effect until some act or event that you set out in the documents, typically when you're considered incompetent by a doctor with a doctor's note. Additionally, you can make that attorney, in fact, you can have their powers be broad and cover all of your finances, or you can limit their power to very specific instances. So, for instance, if you just need someone to sell a house for you and it's in a different state and you're not in the place to be able to travel there, Well, you can designate someone as a limited power of attorney in order to manage your real estate, or even just manage that one piece of property. Now, you can limit that to various financial institutions or banks, accounts. The financial power of attorney is very flexible in terms of the parameters you can put on it, but it is extremely important in managing your assets, specifically your financial assets, when you're unavailable either due to an emergency or incompetency. Now, one note with the financial power of attorney is that it really only extends to non-trust assets. Now, we can put language in your financial power of attorney to where the attorney, in fact, can manage trust assets, but really, if you want somebody to be able to manage your trust assets on an ongoing basis, you would need to add them on as a trustee. So a financial power of attorney, extremely important in managing your affairs when you are unable to yourself. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.